Good evening and welcome to the first live session of our course on intellectual property. And thank you for joining me today. We had received some questions from you and we will hopefully try to answer them. And we had also received, we have been, as you would know, me and my teaching assistants, we have been active on the forum as well. And the questions that you have asked, we have been trying to engage with you and to answer that. But the idea of this live forum is to bring a dynamic component to the course. I mean, it's very hard sometimes to look at a course, especially a course of this nature, which has been offered over a period of time. And sometimes these courses are set to run in a manner in which it runs in a manner in which the students can engage over a period of time without any dynamic component to it. So the live sessions are actually a dynamic component, and I would just want to set the tone for what we should be doing, how we should maximize this, what is considered to be the dynamic component of our course. One, we can obviously look at doubt clearing sessions. I mean, that can happen, but doubt clearing we also do on the forum. All the questions that are asked, I mean, in fact, the people who assist me are also tuned in today. We do answer the questions. So that's the easier part. And I don't think we need to have a dynamic forum for that or a session like that, but we can take those questions up as well. And the people who are signed in on Zoom, or who are on Zoom, you can use the Zoom chat feature, and you can post the chat there. So I'll be looking at the chat so that we can maximize questions that you may get while listening to me, apart from the questions that you have already during the weeks you have spent learning this course. So the dynamic part, if you ask me, has to be something which brings all that you have learned together and also sets you for further learning. The way in which we envisage this course, and I think that is true for all the courses that are taught on NPTEL and SWAYAM, is that we don't want this to be the end of your learning. In fact, this is the beginning, and we are really living in very interesting times. And you would know that many of you would have heard about this new technology called ChatGPT, which has come. It has got huge intellectual property rights implications. I'll just try to touch on some of them so that what you are learning today is relevant for the world to come. And ChatGPT is, without doubt, it is one of the most significant technologies that has. When I use ChatGPT, I'm referring to generative artificial intelligence, generative AI. I mean, I'm referring to it's today the poster child of generative AI. What this can do is I mean, and OpenAI is an interesting experiment because we have not seen the internet, as we know, has not seen a quick adoption of, say, 1 million followers in this shorter time, and it happened in a few weeks. I mean, this is a record in itself. And if you see their recent lot, which is ChatGPT 4, you can see that the ChatGPT 4 was built while it was being tested. So we have a new model where we are testing things and we are also building things. So there are so many firsts if you look at this. And recently, I mean, because we are in learning and in teaching, the founder of Khan Academy, Salman Khan. Okay, it's not the Salman Khan whom we know, it's the Salman Khan who is based out of US. Salman Khan had, or Sal Khan as he is known, Sal Khan had, they have released AI tutor, and the name of the AI tutor is Can Me Go. Okay, Can Me Go, you can check it out. And it's going to revolutionize learning in the sense that your learning can now be personalized. So this is one thing that generative AI is going to bring. Your courses, your learning can be personalized, meaning which you need not start with everyone and end with everyone. You can just start your learning trajectory, or your learning pathway can be quite different from what you know. Two, because the AI tutor is going to be with you and understand your faults, your weaknesses, your gaps, the AI tutor will be much more efficient than any teacher in teaching you, in the sense that it's going to be your personal assistant come tutor. So it's a different take on this. So how does So this is an inevitable part of our world. We are soon going to inherit a world where almost everything that can be conveyed, that involves knowledge, that can be conveyed in some form of digital form, say images, text, videos, you name it, anything that can be conveyed in digital form, knowledge that can be conveyed in digital form, the AI will have an advantage over human beings, and this is inevitable. In that world, if you are looking at synthesizing knowledge, the AI will do it much efficiently than you. If you are looking at engaging with a tutor who can personalize your teaching, the AI can again do that much better than you. Spend quite a lot of time than a teacher can normally do. But the role of a teacher will also change. Just as the role of a student changes, the role of a teacher will also change. The role of a teacher will change in unique ways. Now, the teacher will have all the power on the earth, in the sense that, the entire knowledge on the earth is available through generative AI, and classrooms will be quite different. I mean, I'm expecting NPTEL and SWAYAM will also evolve to raise to that challenge, because we need not teach people in a traditional way. So there's quite a lot involved there. Now, let me just give you the intellectual property implications, so that, whatever you've learned in the course, let's see how that is going to affect this new technology, because this is the talk of the town. So let's engage with that. So there are two things in in a generative AI like ChatGPT. There are two things. One is the input. The input is what goes into it. One thing, and there are IP issues involved there. And there is the output. The output is what comes out of it. And there are again IP issues involved there. Now, the input, largely, you will know, people who have dealt with ChatGPT or like technologies, or DALL-E or Midjourney. DALL-E and Midjourney are used for generating images. And there is also, Adobe has recently come out with something called Adobe Firefly. Okay, so you can check all these things, make notes and check all these things. Very interesting stuff is happening. So one of the input involves IP issues, because the input for an AI or a generative AI like ChatGPT involves the data on which the AI is trained. Okay, the OpenAI is trained on quite a lot of stuff. I mean, if you had engaged with OpenAI, I mean, in ChatGPT 3.5 or 4, you will see that almost it's encyclopedic in its knowledge. So where did it get its knowledge from? The question obviously is that they were training data sets that were used to train it. Now, all of that may not be perfect, but it will get better over time, definitely, like any technology. So today there may be some errors, and the media may be picking up those errors and glorifying them to show that this technology is not perfect. But this is just a matter of time that, those errors will be corrected, and the technology will become much smarter and efficient than it is today. So the input is nothing but human work. Okay, the human work that is there on the internet over a long period of time, more than 30 years, all that could now be used as whatever is accessible, what is not behind a paywall or what is not proprietary, is now accessible for ChatGPT or any generative AI to use that as an input to create stuff. So there is IP involved there. In fact, if you ask some questions to ChatGPT 4, it would say that I do not have access to this. In fact, it means that it's proprietary. And if you are looking at a paid website where there is a firewall and you ask something from there, the ChatGPT is going to say that, it doesn't have access, and it may even say that this is proprietary information. Now, but it does have access to quite a lot of other stuff. So one of the things that has been a pain point in training artificial intelligence or AI, generative AI, has been IP has been a hurdle. Let us face it. And IP has been a hurdle for the same reason. A few years ago, we had the Google Books project. Okay, Google wanted to publish all the knowledge in the world. They got into a project where they would scan all the books and give it, digitalize all the books and make it freely available. Then the right holders came and said, wait a minute, our IP is involved. We don't want you to do that. So you will find this tangle. And this is one of the things that we covered in the course. There is always a tussle between the knowledge that is proprietary, which is protected by copyright, and the rights of the users who want access to that knowledge. So this is a traditional tension of intellectual property. In copyright, it is between knowledge and access to knowledge. So when you write a book, or when you create a work and say that that is copyrighted, obviously that becomes proprietary, right? Others cannot use it. And the people who are building AI, generative AI, are today not using those databases if it is copyrighted. They are not getting into that. They are not. And in fact, AI will never produce the book in its full. If you say that, give me a copy of the book, it will not do that because it knows that it is violating IP laws in many countries. So this is one thing. AI is affected, or the growth of AI or the development of AI is affected by the input. And the input, one of the hurdles that we face in training AI is that much of the input could be IP protected. Largely, we are talking about copyright. And copyrighted matters, people can say that, this is our IP, we will not allow you to use that for training. So there is an input problem. The output problem, which also pertains to IP, is that because AI can generate human-like work, there is always a question on authenticity. The authenticity as in, where did AI take this from? Did AI paraphrase things, or did AI kind of infringe the right of right owners, because AI can now combine many things and present it to you in a format. So there are also issues with regard to the output itself. But the output, I mean, this can be, as long as AI is able to give you references, it can just say that, okay, this is my speech. I mean, I'm just putting all these sources together. Here are the sources. These are not mine. AI can just make that claim, or even the creators of AI can make that claim and say that, okay, there is not the output may be unique, but it's AI generated output. Now, this ran into problem in US. In US, you would have heard about the monkey selfie case. In the case involving a selfie taken by a monkey, and there were some animal rights activists who took it to the court and said that the monkey should be recognized as the owner of the copyright because the monkey took the photograph. The court came down and said that no, today the copyright regime only covers human creators. So the right is only for human creators. It is not for any other type of creators. In that case, they were looking at monkey as the creator, because the monkey just clicked and it took its own selfie. And this is one part of the thing, because the copyright regime, as it has involved, it is to incentivize human creativity and also to incentivize or to reward the human creators. So they said that the monkey cannot be a copyright owner. Now, as we speak, there are various cases in patent offices involving DABUS case, DABUS, D-A-B-U-S, which involves Professor Thaler. He's a professor who has been trying to push AI to be the owner of the patent. So the AI as the patentee. I mean, this again, some of the patent offices have refused the case, saying that, again, just like copyright, only the patents can only be granted to human creators. And AI cannot be a creator. So the case is going on, but it's an interesting case to watch. And the recently there was a development in the US where they said that AI generated work will not be entitled for copyright. And I think that's the right policy to do, because given AI's creativity, they can just bombard any office or any registration system that we have, and we will simply not be able to cope up with that. So this is, IP is a human problem. IP addressed a human problem. IP didn't come to address a machine problem. So this is one issue that you will find, that whenever we want to take human models and put it on machines, we are going to, it's not going to fit well. So we are not saying that AI is not generative or AI is not creative in its own way. It is definitely very creative, no doubt, but it's different from human creativity. Human creativity has different maths, it has different economics, it has different incentives. I would create it just for the pleasure of the creation. I would want to be recognized as the owner. When somebody refers to my book or refers to me as the author of the book, I get thrilled and I get some satisfaction out of it. All these things may not be relevant for a machine. And human creativity is a laborious process. It takes quite a lot of time for a person to compile a book or to write a book, whereas a machine can just do it in few minutes. You can see, if you are engaged with ChatGPT, it can outsmart. I mean, what can be done by human beings over a period of years, it can do it in minutes. So again, we have to have a system of there is no need to incentivize machines. Obviously, we need to incentivize only the people who create these machines, and the people who create these machines, I mean generative AI, are already sufficiently incentivized. You can see that they are going to reap quite a lot of benefits out of this technology, and what they create, they do not know what their creation will create. That's another puzzle in AI. OpenAI didn't know many use cases until it released it. So use cases are going to be evolved as people figure new ways to do it. So this is another thing. If you do not know what you are creating would create in return, then there is a disconnect between what you created and the ultimate outcome. So that could be another reason why you would not be granted a right. So these are the two. I mean, just to give you the gist of what is happening with regard to development of AI. So you have IP issues relating to copyright that can be used for training the AI, and you also have IP issues that come out of AI because that could be conflicting on existing copyrighted works as well. And as I said, the Dabas case pertains to a patent filed by an AI, generated by an AI, and the owner has been trying to file the patent in different countries, asking for AI to be recognized as an inventor. And my take on it, and I've been quite vocal on this, is to say that no, we will not treat AI as inventors, because AIs don't invent the way in which human beings invent. And this is a human system. Let us take that. It's just like saying that, human beings drive in a particular way on the road. And when autonomous cars come on the road, we are not going to treat an autonomous car as an equivalent of a human driver, because a human driver has his own skills, and you are not going to even go through the process. It's like saying that the autonomous car will now has to go through a driving school, do 20 or 30 hours of driving, then take a computerized test, and then do a test where it will be inspected. All that is nonsense. It's not going to happen, because we need not have, I mean, this is one thing that is evolving as we deal with these new technologies. We need not have the same standards that we have for human beings when it comes to machines. So that's one thing that we have to there are some questions. Okay. I'm just looking at the questions as well. So these are some of the things that you need to understand when it comes to IP and AI. And IP is, I mean, if you ask what is one of the most important social sciences, or something that pertains to non-technical stuff, non-scientific stuff, it is IP, because IP deals with creative work. And generative AI is creative in its own way. Law also involves ethical issues. I mean, what can you do and what you cannot do? And we are going into a world where there'll be quite a lot of misinformation, because AI could be used for whatever you want. If you want, it's like a tool. It's like a knife. You can use it for the good, and you can use it for the bad purposes as well. So we are going to look and see a world where there is going to be quite a lot of misinformation, and there have been efforts to curb that. Content authenticity and what is called how to detect the origin of content. There's quite a lot of stuff happening there. There are quite a lot of developments on checking the authenticity of content and the origin of content, because with ChatGPT, one of the things you are going to have a big problem is to detect its authenticity. People can just write stuff on ChatGPT and pass it on as theirs, which is a problem that we are already having. So all these are issues that are connected, which are not technical issues. They are actually social issues, or what we call adaptive issues. Yeah, adaptive issues, which are pertaining to human beings and not to the machines' work. Okay. And nothing is visible because we are not showing anything. I mean, don't worry. It's just once you start posting the questions, then we will probably post the question. We have an Excel sheet. We can probably share the Excel sheet. I mean, okay. Let me just see. If somebody can share the Excel sheet, then probably you can see what are the questions that have been discussed now. Okay. Now one more thing is regard to the rights of creators when they use AI. Now, as I said, AI, when in training an AI, the creators or the people who use the AI have been not very forthcoming in allowing their proprietary rights, copyrighted works, to be used for training the AI. This we already saw in the limitations of developing AI, because there are copyrighted works which copyright owners may say, don't use my work. don't use my work for training. In fact, if you look at Adobe's new launch, which is forthcoming, which is called Adobe Firefly, which combines all the cloud creative cloud tools with AI in it, and you should watch the launch video. It's a phenomenal technology. Adobe has introduced a new feature in their AI Firefly. It is called a do not train option. So the do not train option, as I understand it, is if a person engages with that or enables that option, do not train, then the AI will not use what you are putting into it, the creative work that you are putting into it. It will not use that to train itself. So this is a recognition of copyright that creators have. And you can see that. You can just check do not train on Adobe's Firefly website, and you will find what this do not train is. So we find that this what we said, there is already a tussle between between IP and the manner in which AI is developing today. And one of the things the AI creators of AI or the users of AI are recognizing the rights that creators have, and they are giving an option of do not train. You can if you enable that option, whatever you put into the AI system will not be used by the AI system for training itself. Now, sometime back, there were people who asked, how can we draft a patent using AI? Because once you put stuff into the AI, it becomes public domain. It loses its novelty. Now, the answer for that is this. You may have a do not train button, which you can use, and which you can, now the AI will not take the thing and put it into the public domain, or it will not use that. Okay. Okay, see, any question, I understand this, there are questions on assignments, there are questions on, we have a forum and we have people who have been answering that, and I would leave in fact, the people who assist me are here. If it pertains to any question that pertains to, hold on, if it is a question that pertains to in an administrative thing, then probably we will answer that on the forum, or probably you can Ekta is here, she can just type the answer so that you can see it. Okay, so I want you to now engage because this is an open forum, and as I said, we can keep the administrative stuff away, because this is something which it may be just your problem, in the sense that it's just that you have an issue with assignment submission or something, that we can address it. But use the forum so that you ask things that will benefit a larger audience, because this will be recorded and it will be put up there. So if you have questions that that can affect, okay, let me look at those questions. Please help me to score marks in final exam, please, credit exam. Okay, these are all. If there is something related to the IP course that you did, as I said, the okay, what is the full form of TIPR? Where did you come across it? Was it in the was it with regard to managing IP in universities? I'm just trying to where did you come? I'm just going through the chat on Zoom. Okay, a TRIPS agreement. Okay, sorry. The TRIPS stands for, I mean, see, some of the things are so simple. I mean, you can just Google it and you're going to find it. The moment you type TRIPS, it's going to come. It's a part of the WTO. Now, let me give you a quick overview on what the TRIPS agreement is. Now, first, let us understand what the WTO is. WTO stands for World Trade Organization. It started off in the 1995, and India was a founding member. There are many other countries. A huge number of countries are there. It's an arrangement that facilitates international trade. That's all you need to know about it. WTO, the World Trade Organization, facilitates international trade. Now, there are some barriers to trade. There are barriers in the form of customs barriers are there. Some products, because to protect the local market, the country may charge a higher custom when that thing enters. There are countries that give subsidies, and there is something called anti-dumping. There are quite a lot of things that affect trade. This is an arrangement where countries can come together and they can make trade across borders easier. Okay, trade in what? In goods and services. So this is the idea of the WTO. How do we encourage, or how do we facilitate trade across borders between countries, trades in goods and services? Now, one of the things that happens with trade in goods and services is that there is intellectual property that travels with it. And if you look at today's world, if you have an Android phone or iPhone, which I think covers the entire world. I mean, you did have some, Microsoft did have some software, but anyway, if you have a smartphone today, know that this smartphone, I'll take iPhone as an example. If you have an iPhone with you today, know that this iPhone was designed and developed by a company in the US. Okay, they designed and developed this iPhone, and they didn't manufacture it. They shipped it to a company in China to manufacture it. The Chinese company procured all the raw materials that they wanted, like screen, chip, and all those things, which were manufactured in different countries, different countries. They all came together into China, and they assembled it. And then they put the iPhone software, which was again created by Apple, but shipped, and it was done in China. Then it was tested. And then this phone that was created in China went to all the parts of the different world, including India, and whichever city you are and wherever you bought it. And the system is so robust that when you purchase a phone, say in an iPhone in Delhi, that iPhone was manufactured in China, which brought elements and parts from different parts of the world, which was originally designed in US, and the headquartered in a company in US, and the software was created in US. Now, this entire regime would not have been possible without IPR. It would have been impossible for Apple to create something and send it to China. China would have copied it if there were no strong intellectual property regime, and China wouldn't have shipped it to India. And India, when you purchase it, part of the money goes back to US. This regime is facilitated by IPR, and this regime is there in all the countries today because of WTO. Now, the World Trade Organization has one agreement. It's a set of many agreements. One of the agreement is what we call the TRIPS agreement. TRIPS stands for Trade Related Aspects of Intellectual Property Rights. So TRIPS. I can just Google it. I mean, I would say that please don't ask us questions which you can Google and find out. The world is on your fingertips. I mean, in fact, if you ask something very basic, you do not come out as a very smart person, because this is something that was available for you to ask anyway. Okay, so the TRIPS agreement deals with all the things that we studied. It deals with patents, it deals with copyright, it deals with trademarks, it deals with designs, it deals with geographical indications, it deals with semiconductor chips, plant varieties, all the things that we covered. What this does, it tries to set a common minimum standard for countries so that countries can have similar, if not the same, similar levels of intellectual property protection throughout the globe for this thing to happen. For an iPhone that was designed in California to be manufactured in China and to be shipped to India, so that when you buy a phone in India, the money that you pay, the royalty goes back to the company in California. So this regime was created by, it existed there. It was consolidated by the TRIPS agreement, which is a part of the WTO. So that's a very short explanation on the TRIPS agreement. Sir, I also need full form of WO. I don't know. I think you are referring to the WIPO documents where WO is. It is something I can't. We'll find and we'll send that to you. But the WO is an indication. It's in PCT, or it is in patent that is filed through the WIPO arrangement, which is PCT. So you find the WO abbreviation to distinguish that it's a patent that is filed through under the WIPO, which is the PCT. So this is special thing that is used for patents, because other than this, they will be, if it's a US patent, you will find US and the patent number. If it is Indian, you will find IN and the patent number. If it is CN, it's China and the patent number, JP. And so all patents, for us to know that they origin from a particular country, we have country abbreviations. WO is the abbreviation for a PCT application. Okay. Now, TGA and MHRA are involved in IPR. I really don't know. Probably you are picking something from the PPT, but I would want to know from which lecture that is. It looks like this abbreviations. But again, Ekta, please make a note, and we will just. I would want to see what is the context. I can't immediately see the TGA and MHRA. Looks like something on the management of IP in universities. Looks like it. Anyway, we'll come back to you on that. Okay, tips for scoring in the exam. Okay, it's just this. If you have done the assignments, okay, if you have done the assignments, then it's and if you have done all the videos, this should not be a difficult exam for you to pass, because we are going to repeat all the things that we asked. And if you have done all the assignments really well, you studied, you followed the video, it's just a matter of time for you to do that. So it's just how you tackle, and this is not a hard subject in the sense that, and there's quite a lot of stuff available that you could now look at to clarify your doubts. I mean, if you have any doubts on IP, there is quite a lot of information available. So we would want you to engage with that. And let me just jump to the YouTube live and see there are some questions there. Soft skill development, final results, sorry, will you study assign? Yes, it will be enough that you study, you cover. It will be enough that you cover all the videos. You have to cover the videos because there's no shortcut there. And if you have answered all the assignments well, in the sense that you knew what you were doing, it shouldn't be hard for you to crack this exam. There is a comment, OpenAI ChatGPT. Okay, we just face not visible. It applies to you as well. Whoever asked this question, even your face is not visible. Okay. AI in law. Okay, AI in law is a separate thing. How we regulate. I mean, largely AI in law is the use cases are there. I mean, with the digital transformation, there's going to be quite a lot of AI. There is quite a lot of AI that is going to be involved in decision making. Judges are going to use that. But AI in law, the most exciting part is how do you regulate this? How do you regulate AI? And you have in Europe, we have the AI Act, which will come into force next year, 2024. It's a wonderful act. You can have a look at that. So we will have something similar. So AI, I mean, in law, as in, it'll take away many of the lawyer jobs. I mean, without doubt, lawyers are going to be worse off because of AI. Quite a lot of the jobs that they are doing, contract drafting and all these things, it'll just disappear because AI is much smarter in doing that. So anything that that involves synthesizing or putting content together, which is already there, which some of the legal things that we do involves that, all that is going to disappear. Okay. The assignment answers were getting wrong even after watching the videos. Okay, see, if you see that the assignment answers are getting wrong even after watching the videos, then probably there is the concept of a thing that you are trying to understand. You have not grappled the concept well. That's the thing. So you could do a couple of things. You could ask a question back to us. We can clarify you to some further information, which we have done. Some people have come and asked us. We have directed them to some public domain resources, or you could yourself search. I mean, you have ChatGPT and you have the entire internet in your thing. You could just, so you have to get your concept right. So even if it is copyright, you have to understand what is that copyright protects. And if you look at patents, you have to understand what does that patents protect. So it's technology that is protected by patents. Patents do not protect written works. It does not protect paintings. It do not protect musical or video works. So you need to understand the concepts. Once you get the concepts right, you will be able to see that. You'll be able to answer them. Anyway, you can, if it's a personal thing, please get in touch with us. We will answer that on the forum. Marked wrong. Okay. Again, we need to know the specific. If some answer of yours was marked wrong, you need to send which video you are referring to, what is the question, why it was marked wrong. We'll explain that, and probably that may clear your doubt. Okay. Now let me come back to Zoom now. I just please reevaluate question number 10. Okay. I can't do it now. I understand that you have an issue. please get in touch with Ekta. She's here in the group, and please get in touch. We will sort that thing out. Okay. Thank you so much for bringing this to our notice. We will sort it out, and if it is something everybody needs to know, we will publish it on the forum as well. So the lifetime of a copy, but in the quiz, it is 70 years. Okay, 60 years plus author, 70 years. I think it's for the institution. Okay, just check it out, because there are, see, if you look at copyright, copyright has different entities are entitled for copyright. Individuals are entitled for copyright. Institutions are entitled for copyright. So you will find that I don't know the specific here, but again, Ekta, just make a note of this. They are saying in the quiz, I want to see which quiz mentioned that. Let's get back to that, because again, we need to see the full context of the question for us to give you the correct answer. But it is 60 plus is for the normal case of a human being. So when it is an institutional order, it changes. And in fact, in US, it can go up till 95 years. They have a very long copyright term. And because of the, I think we mentioned that the Sonny-Bourne Act, which increased the copyright term to 95 years. So that's largely to protect some Disney's works. Yeah, please. Okay, see, you need to, as I said, we will not be, obviously, there's no point in us asking the question that we asked you in the assignments in the exam. I mean, but it's not going to help you at all if we just repeat the questions. So, what is critical here is you need to understand the concepts. The concept, and they're very simple concepts. What does the design protect? You should know that. If I ask you, what does the design protect? How is a design protection different from a copyright protection? You should have the answer. Or if you ask that, why is patents used for protecting protecting technology? Why can't we use design for protecting technology? You should have the answer, because it's there. It's there. We have covered that. So you have to be clear on the concept. So if you're not clear on the concept, sometimes watching the video may help, or sometimes, depending on your level, you may have to do some extra reading. The extra reading is nothing but go to the WIPO website or WTO, the TRIPS website. There are very enormous amount of information. So if your particular issue is that you are getting a concept wrong, you have to engage with the material again. I would say that if watching video, sometimes video may not be the best way for learning for some people. I understand that. So find out what works for you. Engage with those questions in the internet and find out. So say if it is fact-based question, you can find that out. You can get the facts right. How long is a patent term? How long is a design term? What is the term of protection for a trademark? These are factual questions. But if it is something that pertains to a concept of understanding, I would suggest you may have to do something extra in finding what to in finding where is the gap in your knowledge, and you have to make that you have to cover that gap. Okay, there are questions on assignment. Please, Ekta is there, and she will resolve it. I mean, you can take on the forum, or you can just write to us. And so again, some questions on assignment. Please, we can't do anything now here. We have to see which assignment it is, which question it is. We have to check our database, and then we'll correct that. Okay, if there is a mistake, we'll correct it. Definitely, don't worry about that. Yes. So let me just switch to the YouTube live. Yeah. Okay. This is all assignment related issues. Okay. We can handle that. So if there is any other question that you want to clarify, as I said, this is largely it introduces a new concept. Intellectual property is a new concept, and all you need to do is, if you do not understand a particular what you call a concept, you may have to do some extra reading. See, because the way we have designed this course is it's just to sparkle or to trigger your interest. You will have to do some amount of reading or investigation, or even watching other videos, so that you can cover the you can come to a good understanding of the concept. Okay, see, just to answer this question, if there is a mistake in the question paper, okay, and the answer is we get to see that. We get to see how people have dealt with it. Many a times we give marks for that question, so don't worry about it. You will not fail because of that. I will tell you. This take it as a guarantee from us, because there was a systemic fault, or there was a technical fault, or there was a typo in the question paper, or there was an incorrect mistake in the question paper. That will not bear badly on you. Okay, it will not affect your passing or failing or getting better marks, because normally what we do is we eliminate that question, or we see how many people have engaged with it and how many people have got it, and then we will even adjust the marks and say that, okay, but let us treat that we will either eliminate the question or give marks to anybody who attempted it. So don't worry about that. We have been running this for quite some time. So if that happens, you are at an advantage. I'll put it this way: if that happens, you are at an advantage, because that question everybody gets full marks. Yeah, but we will ensure that these mistakes do not happen. Yeah, we will check it from our side. Any other questions? Yeah, there is something here. Let me just check that. 3 and 4, what can we cover? Very vast. Okay. Are you referring to section 3 and 4 of the Akash Agarwal? Are you referring to section 3 of the Patents Act? There's a question said about section 3 and 4. Okay, what photograph issue? Are you referring to the monkey selfie case? Okay, just do, I mean, it's just a recent development, so you can just do what you can do is you can just there is a Wikipedia entry on how the case went in the US. It's not directly a part of the syllabus, don't worry about it, but it's an interesting fact to know that how there has been attempts to expand the rights beyond human beings. So I just mentioned it in the context of people now requiring that AI be treated as a creator. AI is a creator, but it's not a creator in the sense in which a human being is a creator. And these systems, 300-year-old systems, the IP systems, have been designed for incentivizing and built for human creators. So when you try to fit, as I gave example of an autonomous driver and a human driver. So if you say that the autonomous driver should go through all the things that a human driver does, it's ridiculous. We don't need to have that. We may have to have different systems, but that's a different thing. But right now, the system is not designed for accommodating machines, machine creativity. It's not designed for that. Okay, the idea, the pattern of the exam is largely multiple choice questions. I mean, you can see that the old question papers are there, but it's just like your assignment. It's largely an extended form of your assignment. There will be questions that have only one answer correct. There will be sections where they will have multiple answers correct, and you'll have to pick all the correct answers to get full marks. Oh, thank you so much, Nagalakshmi. I mean, this is it's really delightful to see such a comment. I mean, thank you so much. I'm very glad the video lectures helped you, and we really appreciate the comment from your side. You just when we started this, the way in which we learn is soon going to change because of generative AI. You will soon find that there is quite a lot, and we will have to. I mean, NPTEL and Swayam will have to rise to the occasion where we become and you're learning. I mean, for all that I've been some of the questions, I can understand that you have some understanding of concept. All that is going to change, because one of the things that generative AI or ChatGPT like technology will do for you, it will personalize your learning. So if you start engaging with the AI tutor, and there are AI tutors that will soon be coming, and maybe NPTEL will have one soon, then the AI tutor will know what you studied over the last 6 months, and it will start giving you things at the level of your understanding so that the concepts get cleared. I mean, we are in for very, very exciting times. When will you get the center and seat number? I'm not sure. Probably the folks at NPTEL will answer that. But don't worry, you'll get a notification on all that. it's a normal process. I'm completely I'm at a loss to answer these questions. Okay, so anything on administrative side, on the back end side, on technical issues, I'm as much ignorant as you are on that. Maybe you have some more information on it. So I just come, teach, and leave. So hopefully, but please ring this up. We will we will be watching the forum closely for the next few days, and we will hopefully address all your queries. Okay. And then you could also search for others. I mean, NPTEL is a huge enterprise, and some of the questions you are asking have been asked by people before, and it's there on the internet. You can just find that. Okay. And thank you so much. I hope you found this Zoom session beneficial. I mean, as I said, this is just bringing everything together and to just add a dynamic part to our course. And let me just see YouTube live if there are any questions. Yeah, okay. Okay, I just answered this. In case you answer a question and you feel that the answer is wrong, or the question is wrong, and you didn't have the right option, we get to know that, because if you had the problem, others are also going to have the problem, and that raises a red flag in our system. So we will normally we give full marks for those answers. But if we find that some people were there are some trick questions sometimes, and some people have got it and some others have not got it, then we will factor that in accordingly, depending on the number of people who got it. But normally we always give the benefit of doubt to the students, and we will not penalize you for some mistake from our end. Please take that. It's been the norm. Okay. Now on section 3 and 4, okay, of the Patents Act, section 3 and 4 pertains to exceptions to patentability. You need to understand them as exceptions, in the sense that everything that involves a technology will be granted a patent, except for this long list. Okay, some of the exceptions are very easy. I mean, and I deal with that in my lecture. Some of the exceptions are easy because they pertain to other things. They pertain to copyright. For instance, literary works are if you find section 3 says literary works will not be granted protection. Why? Because it is granted protection under copyright. So what is granted protection under copyright need not be granted protection here. Computer program per se is again something that is mentioned, will not be granted a patent protection. Why? It can be granted a protection under copyright. Method of or a mode of information, communicating information, will not be granted protection. Why? Same reason, it is granted protection elsewhere. Now there are things like traditional knowledge will not be granted protection. Why? Because traditional knowledge is a property of the public. It belongs to the public domain. A method of agriculture will not be granted protection. Why? Because a food security of a country is tied to agriculture. So we do not grant proprietary rights on a method of agriculture. A method of treatment will not be granted a patent. Why? Because treatment is something that is required to save human life. So we will not grant a method of treatment will not be granted, a method of surgery or a prophylactic. So you will see that there is some logic in this list. So what you would do, it's an interesting thing to do. You could now just classify these 17 odd exceptions into buckets, saying that, okay, this is the copyright. Because we are granting copyright, we are not going to grant patent protection. And this is semiconductor. There's one thing on topography of integrated chips. Topography of integrated chips, there is a separate law for it, what is called the layout of semiconductor chips. Because there is another law, it will not be granted a patent. So if you just draw this list, you will be able to put much of the things in order. And something that inherently harms the human and animal life will not be granted a patent. Like, for instance, in France, they had this guillotine. The guillotine is the blade that is used for beheading people. I mean, this used to happen in Europe. They used to behead people using the guillotine. Now, the guillotine's only objective, you can't cut vegetables with guillotine. Its only objective is to kill people. And the patent offices around the world did not grant a patent over it, saying that it is a machine that is designed to kill human beings. So we will not do that. We will not, because the object of granting a patent is to incentivize creativity. What kind of creativity are we incentivizing, which would lead to harming human beings or eliminating the human race? So those are the things. I mean, so you will see this, and if you see read the section, and you'll see that, oh, these are not being granted patent because it's protected by another regime, or it is something that is against public policy. So if it is protected by another regime, another set of laws, or if it is against public policy, we do not grant a patent. That's it. Scientific theories, E is equal to MC square, cannot be granted a patent because that's something on which the basics of science is built. So a theoretical formula, the theory are things on which the knowledge is built. So we don't want that to be proprietary so that only one person or a group of company or a group of people can use it. So that's why this is opened up. Thank you so much, Srinidhi and Prarthana. Thank you so much for your comments. We really, we are delighted to hear that this course was beneficial for you. Let me layout of semiconductor. Yes. Yeah. Yes. What happens if someone haven't completed their assignments? Azizur Rahman, you didn't complete your assignments. It puts me in a difficult position to answer that now. Okay, but you should get in touch with NPTEL and ask what will be the consequences. And if there is a way out, we are there to help you. Okay. Okay, that's it. Okay, is there anything else? We have roughly a few more minutes. It was designed to be a 1-hour session. So if there is something you want to share or you want to raise as an issue, but the thing is this, I mean, today you have to be, I mean, let me just conclude with this. This format, which is a remote learning format, in which we run a course and with some assistance from us and from my teaching assistants. This format is meant to be only what you call it is only the beginning of your education. Or there are so many limitations to the format. I can tell you this. In 30 hours, we are trying to cover. We are not trying to cover one branch. We are trying to cover a conglomeration of branches of law. Okay, patent law. I don't know whether you know this. You can just check a book called on the internet. There is a book called Chisholm on Patents, CHISUM on Patents. Okay, this is one book on patents. It runs into more than 50 volumes, FIFTY. Okay, 50 volumes. So that's patent law for you. And we are trying to teach patent law, copyright law, trademark law, and many other things in 30. It's impossible. And you have to sympathize with our efforts here. Because it is impossible to teach even one of these subjects in 30 hours. But what we are attempting here is to bring a good introduction to you so that you can be on the path of your own learning journey. And sky is the limit today. I mean, with all these technologies and access to all the information that you have, sky is the limit. So you have to do your part. We have done, I mean, we have confident that we've been doing this over the last many years. We have done our part. Now it's for you to now pick it up from here and do it. And one more thing, thanks for many comments on some of the questions not being correct and answers. We will try to, I mean, going forward, I'm not sure whether we can do it this year. Going forward, we will try to eliminate fact-based questions. I mean, it's ridiculous to question you on fact-based question in an age of ChatGPT. Come on, I see the futility of asking any fact-based question and testing your memory on that, because in whatever work you do, you're going to have access to this technology. So we will now, I mean, it requires some thinking from my end as well. We will now try to convey concepts to you in a way in which you understand the concept. You can do the application is left to you. So I would want to, I mean, redesign this to eliminate fact-based questioning, whether it is 60 years, 70 years, 90 years. I mean, we don't need to do that. I would want to focus on getting all of you to understand the concepts. We have done that. Not that we have ignored it, but with ChatGPT staring at us, we have to eliminate what you can very well learn on your own. We have to eliminate that, and we have to now learn. I mean, as teachers, we have to now learn how to teach you in a way in which we can maximize your learning using what you have access to. And I'm sure all of you would have tried ChatGPT, either 3.5 or 4. 3.5 and 4, there's a big difference. It's big. I say chalk and cheese. For 4 is amazing technology. So the faster you do get onto it, the better it will be for your own learning journey. There's one last question. I'll just take this. Sir, only assignments are enough to clear the exam, or okay, we just covered this. You need to watch the videos. Obviously, that's the study material. You need to understand the concept. Sometimes you may watch the video and you may not get it. Okay, so there is some extra effort that is required. You may have to go online, watch, not watch, you may have to read something. There is enormous amount of information on IP. IP is the main thing. I mean, I just started this lecture by saying IP, how IP affects the input of AI and the output of AI and the regulation of AI. What Adobe is today doing by introducing the do not train option. There is IPs all over the place. So you are not going to come back and say that, sir, professor, I couldn't find something. No, the world is flooded with IP. So this is, as I said, because of the limitations of the format, because we have just 30 hours to teach you, and it's in the remote manner of educating you. We have our limitations, and you need to understand those limitations, and you need to do something extra that will make you set you on a path of your own learning. Because as I said, this is not something that can be completed in 30 hours. It's just the beginning. As I said, Chisholm on patents, just check it on Google. Chisholm on patents is one book on patent law in the US, which runs into more than 50 volumes, 50. Okay, fine. With that, all the very best for the exams. And I hope you will all do well and you will clear the exam. And you should also think about this. In a world with generative AI, and this is going to happen faster than you think, what will be your role as a learner? How are you going to learn things? Are you going to learn things in a linear fashion? In a linear fashion, as in there is a curriculum, there is a book, there is a set of videos, I will watch that and I will get. Or are you going to say that, no, the world has changed, it is quite complex, it is interrelated, there are so many interconnections, I'm going to change my style of studying, I'm going to change the way in which I learn. The entire world is my school, and I'm going to utilize that. So that's a thought on which I want to conclude this. Thank you so much for taking your time and joining, and hopefully we could have thank you so much for all of you, all your comments. It really brightens our day, because teaching remotely also has its own issues. You know that, and we try to see that what can be the best way in which we can enable you and strengthen you and begin your journey in learning. This is just the beginning. Okay, so thank you so much for this, and please do at the end, after you clear the course, please do give some feedback, because as you know, NPTEL goes around into your examination centers and they interview you, and your video feedback is really important for us. If you can give some feedback on how to make, I mean, I want you to ponder over this. In a world where there is generative AI, how should we be learning? And you have to give us the feedback. How do you want us to teach? So one of the things I've quickly learned in the last few months is that I should focus on conceptual understanding of the concepts in law, in IP, so that, all the facts and everything, you can just find it on your own. I mean, it's going to be, the world is moving towards that. Okay. So thanks again, and all the very best for your examinations. Thank you.